இந்த வரைவை தயாரிப்பதற்கு பலர் இதில் முக்கியமாக தங்களுடைய கருத்துக்களை வழங்கியிருக்கிறார்கள். அவர்கள் இதில் மிகவும் இறுக்கமாக சில பிரச்சனைகளில் தங்களுடைய கவனத்தை செலுத்தி இருக்கிறார்கள். அந்த வகையிலே ஜெயம்பதி அவர்களுடைய பேச்சுக்கு முதல் அவர்களுடைய உரைகள் அவர் அறிய வேண்டும் என்பதற்காகவே இந்த ஒழுங்குமுறையை நாங்கள் தயாரித்திருக்கிறோம். அந்த வகையில் எங்களுடைய NRTSL உறுப்பினரான சிவபாசுந்தரம் அவர்கள் அதிகார பரவலாக்கம் தொடர்பாக தனது கருத்துக்கள் அவர் பதிந்திருக்கின்றார். அவை தொடர்பாக சில வார்த்தைகளை கூறுவார்.
To start with, we must say that this document is only a very rough draft. Doesn't embody everything in its proper language or structure in terms of constitutional terms, or even for that matter in a good English as such. But having said that, I think the whole process of devolution of powers is important, because I think I think first of all we must realize that this devolution of powers is not, we are not talking about just the Tamil devolution of powers, the Tamils as such, devolution of powers for the Sinhalese and for the island as a whole, you see. But more importantly, this also should be addressed in terms of, and we also had a bad experience where this devolution of powers has been taken back and withdrawn or diluted. So having said that, we also thought, the NRTS also thought, the name tag of federalism or unitary is not very important. But what is important is the content of what is stated there. But we had a concern whether by having unitary word, which means indivisible, federalism has been unfortunately taken as synonymous with separation. Can we find out a solution which will devolve the powers in the way that is needed without embarking on these whatever called as name tags or basically some misunderstood misappropriated names? So basically what we have come across is and also this devolution of powers must also avoid the what I would call majoritarian rule as such. So therefore the constitutional experts has to come back and meet the aspirations in terms of devolution of powers. I think the devolution of powers are discussed so many times. 30th Amendment was the first thing that we are talking about, congruent list, then there was a provincial list, then a central list. But I think Chandrika's proposal came with a regional list and a central list. So we had prepared a devolution of powers based on those proposals. Plus, I think Varaja Perumal of EPRO also has contributed quite a lot of information on these two lists that he has come out with, which is called regional list as well as a central list. So I think if the constitution can ensure that these lists can be implemented, but this list also covers in terms of basically saying what should be for example, the foreign currency, foreign affairs, foreign departments can be with the center, but at the same time land powers and the police powers must definitely be given to the provincial council. When I say provincial, not only the Tamil regions but also the southern provinces as well. In that process, that list has been incorporated in this NRTSL proposal or submission. And what is more important that we thought was the safeguards of these, so that it will not be diluted or withdrawn or superseded by future governments, so that the trust can be built up. You see. So this devolution of powers is there, and also it has to be followed by safeguards, which I think Chilean will have something to contribute on that.
அடுத்ததாக சேஃப்கார்ட்ஸ் மிக அதிக அளவு அக்கறை செலுத்தி பல ஆய்வுகளோடு எங்களுக்கு தன்னுடைய கருத்துக்களை தந்த சொலிசிட்டர்ஸ் செடியன் அவர்களோட சில கருத்துக்கள் கூறுவார்.
First of all, we need to examine the role of constitution and constitution drafting methods to evaluate the international standards relating to the minority rights. So that's what we are all here to elaborate on that issue. The constitutional guarantees to the minorities of the protection are most effective when they are clearly mentioned and do not contain any vague or conflicting articles or provisions, and do not leave any room for interpretation of implicit terms rather than explicit. So in that, keeping that in mind, we go into a very we call eternity clauses. And I just briefly explain what is eternity clause. An eternity clause in the constitution of basic law of a country is designed to ensure that the law or constitution cannot be changed by amendment. Eternity clauses are a type of entrenched clause that exists in the constitution, especially the examples of the countries at the moment are Czech Republic, Germany, Turkey, Greece, Morocco, and the Republic of Iran, and Brazil, and Norway, etc. But the Constitution of India and the Constitution of Colombia contain similar provisions, almost similar like eternity, but they are not impossible to amend. So there are two different types. So now we go into the history of the eternity clause, and we see, for example, the German one. The eternity clause, Article 1 says, set up essential barriers to prevent a movement or a regime or any political party, any legislation or national commitment to violate or alienate the rights and the powers which is given. So that is the history of the German league. The example goes on to say this eternity clause demands of all state authority for binding the legislature, the executive, the judiciary, and its directly enforceable law. It cannot be abrogated nor infringed upon at any time, neither by the legislation or by the executive order or by an act of parliament or any assertion, decision of the constitutional court. So we are trying to put that eternity clause out of reach of any future infringement or involvement to take that away. So that is basically. So how we apply this is, suppose we have an election coming up in a few years' time, and one of the majority party filled in their election manifesto and says, right, you give us the vote, we will amend it, we will take away these powers, or whatever is given. So this safeguards the eternity clause, even in election manifesto or even in voting, for political purpose or advantage or benefit of their own, they cannot do it. So it's there, once it's given, it's there forever, and it's protected. And that's basically is the eternity clause. And then you have the safeguards to set up in two more steps, either by upper chambers or you call it the second chambers and the constitutional court. Then the two bodies are looking at as an umpire to make sure that the constitution is not breached and it goes in according to what it is meant for. And finally, the implementation. The implementation process, I'll give an example. The Kenyan model in 2010, after the Civil War, they drafted a new constitution. 2010, between 2010 and 2015, 5 years down the line, most of the bills are not passed through the parliament, the acts were not enacted, so they ended up 5 years later, the constitution is still there, but it's not being implemented. So what happened at the end was that the Kenyan government introduced a committee called Constitutional Implementation Committee, CIC. So they had to look into the problems of why certain bills are not enacted and not passed through the parliament and not acted upon. So we don't want to be in a situation, and we want to learn from those mistakes. And we don't want to be here in 5 years' time. We've got a constitution, but it's not implemented, and then there are all sorts of legal challenges going through the constitutional court or whatever. So the implementation process also is another safeguard point that we need to look into very carefully to make sure that whatever is in the constitution is actually being implemented properly. That's what was said last about.
நாங்கள் இந்த அமைப்பை ஆரம்பித்த காலம் முதல் எங்களுடைய நோக்கம் தாயகத்தில் தமிழ் மக்களுடைய அல்லது ஏனைய தேசிய சிறுபான்மையினங்களுடைய நலன்களை பாதுகாக்கின்ற மிக முக்கியமான அரசியல் கட்சிகளை அவை மக்களால் தெரிவு செய்யப்பட்ட ஒரே காரணத்துக்காக அவற்றை பலப்படுத்தி அரசாங்கத்தோடு பலமான அடிப்படையில் பேரம் பேச வேண்டும் என்பதில் நாங்கள் அதற்கான ஆதரவை வழங்க வேண்டும் என்பதில் மிகவும் உறுதியாக எங்களுடைய கவனத்தை செலுத்தி இருந்தோம். அந்த வகையில் இங்கு தமிழர் தேசிய கூட்டமைப்பினுடைய பங்களிப்பை நாங்கள் எப்பொழுதுமே மதித்திருந்தோம், எப்பொழுதும் அழைத்திருந்தோம். அந்த வகையில் எங்களுடன் தொடர்ச்சியாக செயற்பட்டு தமிழர் தேசிய கூட்டமைப்பினுடைய தலைவர் ரட்னசிங்கம் அவர்கள் தேசிய சிறுபான்மையினருடைய உரிமை குறித்து அடிக்கடி தனது கருத்தை கூறி வந்த காரணத்தினால் அவர் தனது கருத்துக்கள் சிலவற்றை.
Thank you. First of all, I must thank the NRS because we have not deserted Sri Lanka. It's a constructive decision. We were forced to leave, so we have all the right to participate in the constitutional process. And second thing, my views are not the official views of the TNA. Though I have helped the NRS in certain matters. As far as the TNA is concerned, the position was taken that we have given all the proposals given by the Sri Lankan government, from Bandachelva, Dattachelva to Chandrika and all the other proposals. So based on that, because when we say something, instead of asking for us, the Sinhalese leaders themselves have proposed certain things and it has to evolve from that. That was the official position taken by the TNA. Now, as far as the process is concerned, I understand that there will not be a concurrent list because I'm not sure, but it should be. If the problem cropped up because of the concurrent list. And if you remember that just after the northern provincial elections, and Mohan Pir is the former Chief Justice, took up the case in the Candian province, central province, and made a judgment that the land power is vested with the central government. And he cleverly quoted a judgment from Sharwan, the former Chief Justice, also in that judgment. So when there is a concurrent list, it has to be very clearly stated what are the powers. But I hope that there won't be any concurrent list as to the powers. And also, for example, if there is going to be a land matter, if the central government want to acquire any land for the central government purpose, they should go through the constitutional court or the land commission, and thereafter the constitutional court if there is any dispute. So I think the steering committee should take into consideration of minimize. We don't want any concurrent list. If there is going to be a concurrent list, it should be minimized, and also there must be a process to resolve the matter through the land commission or any other commission and the constitutional court. And as far as the judiciary is concerned, when I mentioned the former Chief Justice, the independence of judiciary should be protected. This is one of the reasons that demerger happened, northern and eastern province demerger happened because of the influence made by various people in the judiciary, and in future at least the judiciary should be more independent. And I don't want to take much of the time because the keynote speaker, Dr. Jayampathy, is here. After he elaborates the process, then we will, if there is any doubt, we will pose the questions.
அடுத்ததாக நாங்கள் இந்த வரவுகளை தயாரித்த போதும் தமிழ் மக்கள் மத்தியிலே காணப்படுகின்ற அல்லது புலம்பெயர் நாடுகளிலே வாழ்கின்றவர்களுடைய மனதிலே காணப்படுகின்ற சுயநிர்ணய உரிமை குறித்த கவலைகள் அதிகமாக வெளிப்படுத்தப்பட்டது. அதில் மிக முக்கியமாக சொலிசிட்டர் பரமலிங்கம் அவர்கள் எங்களுடைய கலந்துரையாடல்களின் போது அவற்றை மிகவும் உறுதியாக தெரிவித்ததை நாங்கள் அவதானித்திருந்தோம். அந்த வகையில் இன்றைய தினத்தில் அவருடைய கருத்து மிக முக்கியமானது. சில வார்த்தைகள்.
Dr. Jayampathy, first of all, I wish to comment briefly on the document submitted by the NRTSL. As far as they are concerned, they have put the aspirations of the Tamil people in a very mild form. They don't want to offend the Sinhalese people, or they don't want to destroy or create any sort of disturbances in the constitution making process of Sri Lanka. Therefore, very basically, in a polite way, they have expressed the aspirations of the Tamil people. Before, they have elaborated everything in an appropriate manner. This particular guide or the presentation needs further discussion. At the same time, my very brief comment is on two aspects. If I am treating myself as a Sri Lankan, what I expect from the constitution. As far as Sri Lanka is concerned, we have in the both constitutions adopted Buddhism as a state religion. We have no unhappiness about it as far as Buddhist philosophy is implemented fully. When Sri Lankan state is in 1972 and 1978 proclaimed Buddhism as the state religion, whatever the fund of the Sri Lankan government, as far as state fund of the government is concerned, public fund is concerned, it should be guided, it should be implemented according to the principles of the Buddhist philosophy, Buddhist principles. Unfortunately, as general public, as ordinary people in Sri Lanka, as far as the public fund is not managed properly, in a way I wish to use a word, it has been looted. So the future new constitution must elaborate and find the ways to protect the public fund of the country. It should be safeguarded from the politicians, not from the general public. That's the way the situation has created. Second aspect, another point I wish to emphasize, when Tamil people ask for our rights, immediately Sri Lankan government and the leaders, they talk about the territorial integrity and sovereignty of the state. I wonder, in the past, how many land mining agreements have been awarded to multinational companies, which is undermining the national sovereignty. At the same time, recently created Port City in Colombo, Port City artificial island, is going to be take away national sovereignty of the government of Sri Lanka, and China is going to exercise the sovereignty of the Tamil people, sovereignty of the Sri Lankan government. As far as Tamils are concerned, we want to cultivate the land without any interference in our areas. We want to enter the sea without any fear in the seas of Tamil areas. And we want to manage our day-to-day matters. Other than that, we are not interested in anything. We are not asking anybody for the foreign rights, currency rights, or we are not demanding. We are asking only for to manage our day-to-day life. Another few, as a constitutional expert, I wish to emphasize, elaborate on 2 or 3 points which are vitally important. As far as Sri Lanka is concerned, or particularly Tamil people are concerned, we seriously worry, we is concerned about the improper decolonization took place in 1948. As far as decolonization is concerned, it has unified the country improperly and without giving due rights of the Tamil people, or without restoring their sovereignty which were taken by colonial rulers. Again, under the UN system, you may feel Sri Lankan government is obliged to implement various international regimes. If I can highlight 1 or 2 of them, particularly as far as the fundamental rights covenant is concerned, covenant on civil and political rights, and second one, socio right. Both covenants, Sri Lanka is rectified and is a party to the particular treaties. Both covenants in the Article 1 respectively emphasizing right to self-determination. As far as Sri Lankan government is concerned, I believe it is the second amendment to the 1978 constitution. They have emphasized if anybody is advocating for separatism or divide the country, it is an offense either in nationally or internationally involved. Therefore, it is fundamentally contradicting the principles undertaken by obligation of the Sri Lankan government. Therefore, we invite you to consider and comment specifically on that point. Dr. Jayampathy, as a constitutional expert, I am sure I don't have to go in detail about the Quebec sovereignty referral case, and also international court discussed on the legality of the Kosovan unilateral declaration of independence of Kosovan case. I am very specifically focused. In these two cases, judiciaries and the judges emphasized obligation of the state. Within the national context, if a state wants to rely on the sovereignty or territorial integrity of the state, it is conditional. It is not a sovereignty. State cannot exercise the sovereignty without fulfilling the obligation of the state, national obligation and international obligation. In the Quebec case, Canadian Supreme Court found any state, if they want to rely for the national sovereignty and right to sovereignty and territorial integrity, they have to fulfill certain conditions, including minority rights, federalism, constitutional protection, and emphasizing relying on democratic conditions. Therefore, I wish to invite you to comment on how do you think the new constitution will eliminate the fear of the Tamil people, and how the government of Sri Lanka intends to unify the country by delivering constitutional justice. Thank you.
நன்றி. இன்னும் 5 நிமிடங்கள் மட்டும் இந்த கருத்துக்களை கேட்டதற்கு இருக்கும். 2 பேருடைய கருத்துக்கள் இருக்கின்றன. நாங்கள் இந்த வரைவை தயாரிக்கின்ற போது 2வது சபை அல்லது செகண்ட் சேம்பர் என்று சொல்லப்படுகின்ற இந்த சபை எவ்வாறு தேசிய பிரச்சனைகளையும் தேசிய சிறுபான்மையினங்களுடைய பிரச்சனைகளையும் பாதுகாக்கும் என்பது குறித்து ஸ்ரீஹரன் அவர்கள், சொலிசிட்டர் ஸ்ரீஹரன் அவர்கள் வற்புறுத்தி வந்தார். அவருடைய கருத்துக்கள் சிலவற்றை கேட்பார்.
Ladies and gentlemen, I can address this as ladies now because Mrs. Chalian also has arrived here. So, ladies and gentlemen, first of all, although it is limited to 5 minutes, Ramba has strictly told me when I walked in, because he knows that the lawyers don't stop talking. But I am the 4th lawyer talking in this forum now. I have to spend 1.5 minutes on these 2 points out of this topic, Dr. Jayampathy, because you are not getting the credit which you deserve. All these luxuries we are enjoying of the new constitution, you were the main player. In addition to Sobita Thero, I can see Roger is shaking his head. You are the one who brought in the common candidate phrase to the Sri Lankan politics of Sri Lanka. I was also confessed that in October and before October 2014, when the Prime Minister then leader of the opposition came, this common candidate phrase was very anti, and we were all anti, including Roger, because we didn't like common candidate because we had one candidate. So you deserve that credit. People are forgetting the history. Sri Lankan, whole Sri Lankan habit is forgetting the history. Therefore, I like to, in this forum, give you the credit that you have given this luxury for the whole Sri Lankan citizens. The second point I have to take is, I think, deliberately or tactfully, Thamba and Mr. Jayadevan hasn't given the credit to this NRTS. I want, Doctor, to take this message that NRTS consisted of a lot of you, people who have been involved in bloc, EPRLF, various TNA, various. Sam is here from Tello. Like that. This is the forum of the silent majority of the Tamil diaspora. So I want you to take that message. This is not just 50-60 people opinion. This is the silent majority which has expressed this opinion. Now, in this process of bringing this document, I showed interest because a lot of people or many people want to show interest other than merger, devolution of power. I showed interest only on 3 topics. That is the independent judiciary, why I am passionate about it. For your information, doctor, I was involved in the past 10-12 years about independent judiciary. Ukul Jasuria was in the heart of the RISC when he was the president of the Bar Association. He is a good friend of mine and a batchmate of mine. So we were very much interested and we were objecting and carrying on the impeachment of Chief Justice Kirani. So because of that, the outcome was Rajapaksa government even refused my dual nationality application. Now it has been fast-tracked by the Prime Minister. Why that independent judiciary was passionate in my heart was earlier days the independent judiciary was left to independence of the judges. Panam Rajaratnam Justice came to London University and gave a speech 20 years or 22 years ago, and he said, no, in Sri Lanka, the judge, the rulers don't interfere with the judges, but the judges themselves are not independent. They know what to make the rulers happy. But that was the situation at that time under Madam Bandaranaike's government. Then subsequently it eroded in the last 10 years. In the last 10 years it eroded, and it has come directly to the rulers to appoint and tell the judges what the judgment they want to be written. I don't need to tell examples and lose my time on that. The last icing on the cake was appointing Mr. Mohan P. with parachuting him. I have nothing against Mr. Mohan P. He was senior to me, I know him well. So that part, a lot of people might not have realized what is BC. You are a president council as well. So I want you to have passionate view about independent judiciary, and I want you to maintain that. Please take it from English judges, not from American judges, because they are the president appoints the Supreme Court judges. So here there is a system. The judges in this country, I am proud to be an English lawyer as well. The judges are very independent in the judiciary. So I want you to take that judicial appointment very serious and put an infrastructure. We are not here to tell the infrastructure. I will take Chairman 1.5 minutes on the second chambers, because 3 topics I was very passionate about. The second chambers, independent judiciary and Bill of Rights. Bill of Rights, I am not going to go into that. I don't know whether the panel will allow the expert on this forum. In my opinion, I am just quoting this without the permission. Bill of Rights is the master of Bill of Rights is Mr. Rajanayake, who had done a lot of work for the last 35 years. I don't know whether the panel will allow him to make a view about that. Second chambers is, doctor, is not a new thing for Sri Lanka. We had a second chamber. Through the old Solitary Constitution and all this, we had a Senate. We had senators. We had respectful legislators through Senate. But we destroyed that in the D.R. Javadana Constitution and gave the cover as a national list. But national list has become national list. There have been a lot of national list MPs. Even now, there were Jayampathy Justice Rajaratnam, Lakshman Kadagaman. There were a lot of good nationalist MPs. The purpose was to bring in people. If Prime Minister or President said, Dr. Jayampathy, you go and contest in Kalatra, you won't do it. And it is a loss for the Parliament if Dr. Jayampathy is not there. So, but that is not enough. Why? The past 12 years or 15 years, the nationalist MPs have become a saleable product. So, to cover that, the second chambers is the important thing that will at least all the draconian laws which come, that will bring awareness of the people, of the whole country. So I want you to take good things from the second chambers in UK and how we can make up that, and I want you to seriously consider that. I have made this, when I personally have made this request to the Prime Minister and to the Speaker, Mr. Kanakasuri as well. They were not immediately outrightly rejecting it. I'm sure you are in the heart of the constitutional making. I hope you will take that message to do that. Therefore, this is a diaspora's message. NRT's message is diaspora's message. I want you to take this seriously because the diaspora don't want to do any more conflicting politics, confrontational politics. They want to be part of that. They want to be part of the system. That is the vote. Northern Tamils also have voted in the presidential election and in the last election. They have voted for people who want to be reconciliation politics. So please take that and take them. See, there will be tiny minorities who will make noise. Gaman Pillai is there. There are so many Gaman Pillai in Tamil community also. But the majority of the Tamil people want conciliatory politics and they want right. Why, finally, Doctor, why I concentrated on the three topics when in the process: independent judiciary, second chamber and Bill of Rights. If it comes and if it is strong, all the communities, all the citizens will be protected. You don't need to protect only Tamil community, Muslim community, Burghers or Sinhalese, all the communities will naturally be protected. The final point is, last night you would have seen some of the news. A Muslim Pakistani origin working class man who became a barrister has been elected. I have my reservations about that, but it is possible in this country. It can be possible in our country as well. Sajid Khan. So that is possible. So we have to have that wisdom. We should not neglect the British model and the Indian model in your evolution of power. Thank you very much, ladies.
நன்றி. இனிமே 2 நிமிடங்களுக்கு இந்த கலந்துரையாடல்